Okay, welcome everybody on the second day of our conference. With this panel, we will immerse even deeper into the cargo carrier liability. We have three excellent presentations, and I learned yesterday that Frank Stevens was initially not invited into our panel, but we welcome you happily. We are happy to have you on board, and I think that all of the presentations they present like a coherent block of knowledge. Two first ones, as I predict, they will talk about the future of the Rotterdam rules, and then the jurisdictional clauses match with the second presentation, which also deliberates on jurisdictional issues in the Rotterdam rules. So with that, I would like to invite Professor Časlav Pejović. All the bios of our presenters are in the booklet, so I will skip that if you don't mind. And Professor Časlav Pejović, the floor is yours.
Thank you, Susanna. It's very nice to be again here. I'm becoming kind of a permanent member of this conference. And today I'm going to talk about future. Yesterday we had the excellent presentations about past history of development, and now we are in difficult moment what to do now. And I'll try to make some proposals about that. Yeah, this is current situation. Hague rules. Still quite a number of countries, but only USA is, which of course Slovenia, I should not forget Slovenia is member to Hague rules, and some countries like Malaysia, but not major nations are member to Hague rules, regional Hague rules. Hague-Visby rules, less countries, but more influential. Very importantly, United Kingdom, Scandinavian countries, France, Denmark, Belgium, Netherlands, Italy. So this is leading and most influential legal regime at the moment. Hamburg rules, 34 states, but none of major countries. Latin America, few from Europe, most of them don't have sea. African countries, so it's we cannot say this was a success. And Rotterdam rules, which was promising, but so far only 5 states. And these are 5 states. Spain was first, and then we have 4 countries from Africa. The last ratification was 2019. So 6 years have passed and no country has ratified Rotterdam rules. And 20 actions are required. I found information, I'm not sure if this is correct or not, that 80% of all bills of lading are governed by English law. So if UK is not member, then we have a problem. CMI seems to be very enthusiastic still to revive. I was attending conference in Tokyo. I could hear that there are still hopes that Rotterdam rules can be revived. They're kind of committee, and I think there is a kind of, that's what I've heard, lobbying in the EU to put pressure to ratify this convention. Jan Ramberg, my dear friend, unfortunately he passed away a few years ago, and these are his words when Hamburg rules was adopted, was conference in Hamburg. The best would be if the Hamburg rules become a total success. The next best is that they become total failure. The worst is that they become a partial success. Can we apply this to Rotterdam rules? I think it's time to wake up. If Rotterdam rules enter into force with this lobbying, and we have EU member countries with 4 African states, this would not be more unification, this would be more fragmentation. And it's highly unlikely that both UK and USA will ratify this convention. So without them, does it make sense to push for ratification of Rotterdam rules? To have enter into force, but then what is the effect? Okay. Yes, Rotterdam rules I was critic of Rotterdam rules. Actually, Jan Ramberg, he told me that, invited me, there was a kind of informal group of scholars that opposed the Rotterdam rules, which included William Detley and Jan Ramberg, a few number of other leading scholars, and I was invited. I said, yes, okay, but then nothing happened with the rules. So our opposition also disappeared. Look at this, and this is only part of Article 47, and it's paragraph 2. Paragraph 1 is missing, and there is second page. And what was trying, this is about problems with some parts of the text. What we have problem here is that we have negotiable documents, but goods can be delivered without surrender of documents. This contravenes the very nature of negotiable document. What kind of negotiable document is if you can receive the goods without showing your, because this is wet papier or a document of title. By having document in your hand, you have rights embodied in your document. But I have a different story. Without bill of lading, typically, the goods can be delivered under instruction of the shipper. Then what is position of the shipper? Does he have right of control? No. By transferring bill of lading, he loses right of control. The right of control is, which is defined in Article 51 of the Rotterdam rules. Right of control has the person who has a document in the hands. And shipper has transferred. And on what legal basis can he advise the master to whom to deliver the goods? If we have stringent sale, that we have the goods are resold several times, he has no idea. Shipper has no idea who is the person to deliver. And why he would? This is another. You can say it's you struggle to understand the meaning of this. You spend minutes and minutes, maybe more, just to grasp what does it mean this. And this is not what practice needs. Practice needs something like Hague rules. Very simple. The people are familiar with that. And now we try to create a very complex, of course, for me that was nice because I wrote a paper about this. So for scholars, this is nice because we can write papers. But for practice needs clarity. And this is too complicated, too complex, and unfortunately, I must say my opinion is wrong. Yeah, how shipper can know how he can advise to whom to deliver the goods. Then he has no right of control. He has no any obligation to give instructions. And then he is risking his own liability. Why he would risk? Because why he would bother to give any instructions to the carrier, to the master? Was this acrobatic necessary? Because the main problem that actually electronic documents will solve is delay. Because the bills of lading are somewhere in the banks. Banks has a few days to check whether the bill of lading descriptions complies with instructions. And very often the goods arrive at port of destination, but bill of lading is not there. With faster ships, with container handling of goods very, very fast, we have that kind of situation quite often. And this was the major reason for this Urstal model on electronic transport trade records. It's about to solve this kind of problem. And then you have a very nice part, which is one of the best parts of Rotterdam rules, but electronic transport document. And then you have something which is supposed to solve the problem that electronic documents will solve. Yeah, was it necessary to invent? Because this invention, this is not negotiable document. This is negotiable document minus, because you don't have to surrender it. This is not the usual negotiable document that we know what is negotiability. So it's not a real negotiable document. It is called, but it is not. And then, was it necessary to, because delivery of the goods without bill of lading is considered as fundamental breach of contract. You cannot limit liability. Pindai Club will not indemnify. This is something to be discouraged as something which is wrongful. And now Rotterdam rules are trying to legitimize something which, by everybody, every jurisdiction is considered to be wrong. Yes, I think that's the main problem with Rotterdam rules was that it was too ambitious. It tried to solve too many problems, and it's too long. I think Marco mentioned 96 articles compared to very, very short Hague-Visby rules, complex, and this is not suitable because practice needs clarity and something simple. Because you can imagine these are not legal scholars of maritime law. People in practice, they're practitioners. They don't want to bother to try to understand all these kind of complex legal issues. Okay. Yes, my personal view is that what was required is to use Hague-Visby rules as the core, as the basis, and to adopt kind of minimalist approach to change only something which is necessary. Of course, it's outdated. The limitation liability is ridiculously low now. We have electronic transport documents. We have number of issues related to containers, and this kind of issue should have been added to something that's very important point. The practice is familiar with Hague-Visby rules, and now facing something unknown world that's for practice. This is something for most I think is something unacceptable. Yeah, common rules. You have nicely drafted convention, but then it's favored. Yeah, that's what I'm going to talk now. I will make some suggestion about what could or should be done in current situation. So I'll just pick up several provisions from Hague-Visby rules that we need change. One is, I think, really I mentioned problem with carriers. It's not clear because Hague rules are not clear. They say charter or ship owner, but they don't specify. And carrier can be either ship owner or the charter. In case of time charter, when bill of lading contains the name of the charterer, like cases Hector and Starsin, then the charterer is carrier. And Rotterdam rules actually solve that problem. I have no objection to this. So this is one, because I'm not 100% critical of Rotterdam rules. They have a lot of good provisions, and this is one of them that I would recommend. That would be solution for the problem of the carrier. Yeah, we can discuss maybe whether some word can be used or not, but I think this is a correct way to solve the problem. Yeah. Scope application, only document of title or similar. And now we have practice that we have number of other documents like seaway bill, which are increasingly used. Why the convention would not apply to seaway bill? Typically, it applies because there is a paramount clause in the document. So I think definition should be expanded to include both negotiable or negotiable and negotiable documents. Or straight bill of lading is a strange situation in English law. Straight bill of lading is a similar document of title under the Carriage of Goods by Sea Act 1971, and it is not document of title under Carriage of Goods by Sea Act 1992. It cannot be both. I think that this should be resolved in some way. Is it one or not? Because this kind of, it depends. I don't think this is good in law. Amsterdam Model. This is very important. That's something that later there'll be some, we have one session that will discuss this issue. And it goes farther than Rotterdam rules and better, more clear, more suitable. I think this should be part of the new convention. Amsterdam model law solves the problem of acceptability of electronic documents by creating functional equivalence of possession, because the key issue was about possession. And if you have interest in that, I would recommend to read the Law Commission report about electronic transport documents. They have extensive coverage of possession. You can write your papers based on that. Why? Because English took a different way from everyone else. That was instead of relying on the text as it is and accepting control or exclusive control as functional equivalent of the possession, English law adopts a different way, keeps possession and extends the concept of possession to electronic documents. Instead of creating a new concept, which would be called exclusive control, English law has taken a very pragmatic, I have no problem with that. And it's because I think this was related to internal things, because they have well-developed body of law dealing with possession, and instead of creating new concept which would need the clarification, the Law Commission proposed, and that was adopted, the function of possession has been extended, the concept of possession has been extended to electronic transport documents. So basically it's the same thing, it's just different names. I think this will not create serious problems in practice. Yes. Then I attended this conference in Tokyo. Your friend had very interesting presentations about live animals, because now we have this kind of exclusions of goods on deck and live animals. And is it necessary to change that? Particularly with containers. Containers on deck now. So there should be, again, this is good provision from Rotterdam rules, so something which became practice, that certain kind of goods can be loaded on deck, and then you avoid the problem of exclusion of application. Live animals is more complicated because there is now kind of topic about animal rights, and Frank's colleague was quite concerned about how they are treated, because they are kind of, can I say, inhuman condition on the vessel, that they are not really, it looks kind of cruel to see how they are packed in a small space. And this is how the times are changing. Once upon a time, slaves were treated as goods and could be jettisoned. Now something unthinkable. And there are a few cases about the general average, because there was not enough food on the ship or water, and then the master would decide to throw into the sea slaves. And now we are talking about animals. And then what can be done? I have no clear idea. I don't think this can be addressed in the convention. Maybe it should be addressed in the way the live animals are treated but that would be different kind of text. But this is something that, of course, deserves attention. Yes, this is a system that I would preserve, because, as I mentioned a few times, practice is familiar with this. We have this kind of very simple structure of the Hague-Visby rules, and that's my proposal is to retain this basic structure instead of having very complex and complicated like Rotterdam rules. Keep something which practice, that's very important, practice knows about, became familiar with, and with case law, despite some problems of clarity, this is something which works in practice. I must say I'm not really fan of the Hague-Visby rules, absolutely. I think some provisions could be drafted better, but it's very efficient, and that is the most important thing. Periods, yes. Something that arises in this case that Zoran was talking about. Hague rules apply from the moment the goods are loaded to the time they are discharged. And how? What happens, I think Lydia mentioned, after the goods are loaded, or after the goods are discharged, but still in charge of the carrier. And Rotterdam rules adopts better. This is better solution, which is fair. When the goods are in charge of the carrier, so from the moment the carrier receives the goods, he should be liable for them until the moment of delivery. I'll just repeat, discharge and delivery, I think Lydia mentioned. Discharge is one thing, is physical act of discharging from the ship, and delivery is legal act, delivery to the holder of the document. Carrier duties, yes, something about seaworthiness, and that's one of problems with the hard rules, that the goods should be, the ship should be seaworthy before the voyage starts. And what happens if the ship becomes unseaworthy during the voyage? And of course, the courts get kind of interpretation. Very often they would try to link that unseaworthiness existed already at the moment before the voyage, but this is kind of how say, gymnastic you extend by interpretation instead of having a very clear, like Rotterdam rules. Yeah, that's again. So some of my praise goes again to Rotterdam. As I mentioned, some provisions are excellent. This is much better than the hard rules. And during the voyage, because master or carrier should be liable for seaworthiness of vessel not only before the voyage but also during the voyage. Liability for delay, and this is, I have one recommendation which is in line with recent developments relating to protection of environment. And I would rely on the Salvage Convention 1989. It's not only salvage of people and goods, but also salvage for environment, which is very important goal. And I think this provision, which exempts the carrier from liability for delay, should be extended to protection of environment. I don't think this is controversial. This is controversial. Nautical fault. This is a thing, and I'm not sure if you know for the case. This is the only case in law that employer is not liable for negligence of employees. I don't know any other case in any law, because normally employer is, if employee is negligence, employer takes liabilities responsible. In carriage of goods, this is current law. It's law in Croatia, it's law in the United States, it's law in United Kingdom. Nautical fault. What is justification? There was kind of, at the time of drafting, that ship owner has no good contact with master on high seas. But this does not hold water anymore. I mean, you know, it's you're in permanent contact with your master. Why you should not be liable for nautical fault? Yeah, but yeah, something which in Japanese they say that hone tatemae. Hone is real thing, tatemae is something that you say. So this is about formal justification. This is tatemae for public, but the real thing was trying to find a compromise, because that was hard rules, trying to find the compromise between cargo interest and shipping interest. And as a part of compromise, we have this kind of nautical fault. And that is the most logical explanation I can give you. And I think someone was talking about, I think Michael Sturley, about compromises. Yeah, compromises are important, but these are good for finding political solution, but not good for making law. When you make compromise in making law, you often adopt something which is not so good because majority would support that. Yeah. Now in 21, is there any justification? Sometimes I say for this exemption, it's bizarre, because I think it's bizarre to have, particularly with I'll give you this case, given, I'm sure if it works. You have heard about ever given, and most likely, yeah. Okay, and what was problem with ever given? It's either pilot or master, nautical fault. So for all damage to cargo owners, ship owner is not liable because nautical fault. Not only that, but cargo owners who have already had loss without any fault on their side have to contribute to salvage to general average. This is unfair. This is something which is because one who is liable for such huge losses at the end is not liable. And he can cover limit liability, he can get compensation from P&I club, basically almost at free. And those who suffer because of fault of the master, then they are not compensated. Okay, particularly with autonomous vessels, I mean, how can use nautical fault when someone is in command, not on the vessel. This is small thing. This is just merging two parts of Hague rules. I think there is no reason, there is no justification to have G and H. They can be like in Rotterdam rules, they can be in one provision. Order of proof, yeah, this should be retained. I don't think this now requires some changes. Yeah, common rules may be clearer, but limitation, yeah. Something which still represents a problem is what is unit under the original Hague rules. And I'll give you one example of English law. Aquasia was 2018 or 19, I can't remember the case. Bulk cargo, and the court said that there is no limitation in case of bulk cargo. That's I find it strange because this contravenes the concept that the ship owner should have right to limit, but in case of bulk cargo, there is no such right. And contrary is, you can see American law and many other European laws that provide for customary freight unit, the way how the freight is calculated. And yeah, sorry. You have, for example, rice in bags and rice in bulk. If the rice is packed in bags, there is a right to limit liability. If the rice is in bulk, there is no limitation of liability. What is rational? I don't understand. Of course, this is very good for cargo interests, but not for ship owners. Yeah, this is about bill of lading, which may need some changes. I think Rotterdam rules are better because under Hague rules is either or, which means you can state number of bags but not weight. I mean, what can you do with empty bags? Of course, you have right to insert notations, but I think as a matter of principle, Rotterdam rules are better drafted. Evidential value, okay, this is something which does not pose problems. Yes, this is problem with drafting of Hague rules. That in case of some serious doubts about accuracy, the master does not have to state in the bill of lading quantity or weight or. I think it's better because the practice has developed practice of inserting notations. So instead of saying this kind of unclear language, this is better Rotterdam rules, which is based on existing practice, because practice has solved the problem of shortcoming in drafting of the Hague rules. Now we have a very clear provision that in some cases the master has the right to insert notations in bill of lading. What would be additional issues that can be discussed? I think multimodal carriage, I think Michael Scully mentioned that. I think that would have to be addressed, and that is quite complex and complicated issue. Volume contracts, I have some doubts about that, because this is not really real carriage. It's more kind of booking space on time, then maybe performing and contracting contractual carriers, which is addressing number of conventions. Because in case of charters, you have someone who is actual carrier, someone who is contractual. Dangerous cargo, I think it's addressed in Rotterdam rules. If the goods are dangerous, I think this shipper should declare them. I think it's Article 32 maybe of the Rotterdam rules. So there's a few things that we have to clarify. I gave some hints about what I would change, but this requires much more serious work than this kind of short presentation. I have my AI twin. If you want to ask me questions, you can ask my twin. This is code that you can. It's my ex-student, Lithuania. He started business in Silicon Valley in California, and he asked me, "Do you want to create for you AI twins?" I said, "Okay." But the answers are much different than I would give. So if you real answer, you should ask me. Because my twin is very, like in Wikipedia, very, very straightforward and without explanation. I always like to give a broader explanation. Why is this and what is? This is okay. This is AI. Thank you.